thank you for joining us today. My name is Young Ki-hong, and I'm a senior associate at Scott Legal PC. Today's webinar will focus on how to move from a non-immigrant visa to a green card in the United States. We are very fortunate to have our firm's managing partner Ian Scott as the speaker for today's presentation. I will begin with the overview of family-based green card categories, and then Ian will discuss more detailed practical guidance on employment-based green card cases. Before we dive in, let me briefly introduce our firm and go over a few housekeeping items. We are a full-service immigration law firm, and we offer representation across a wide range of practice areas, including E2, O1, TN, L1, H1B, and all types of employment-based and family-based green card cases. That said, we are particularly well known for our work in the complicated green card cases, and we have built a strong reputation through our comprehensive approaches and strategies. We have processed thousands of these cases and have been able to secure approvals for the vast majority of them. At the end of this webinar, we'll send you several useful tools. A copy of the PowerPoint presentation we'll go through today, and a link where you could download the guidelines with more details on visa options, a link to sign up for additional webinars, a link to webinar recording on our YouTube. We definitely encourage you to subscribe and hit the notification button as we regularly post immigration related videos. And finally, a link where you can set up a private consultation with our team. Finally, for any questions, please type them into chat box or Q&A box. We'll address all the questions at the end of presentation. And with that, let's get started. So how does green card system works? So the first thing that we need to talk about is the systems, the green card systems in the United States. The U.S. permanent residency, green card means permanent residency, system is quite different from our other countries. For example, in Canada, they use like point-based system, which gives you points of all different things like education, language abilities, and work experience, age, and other factors. Another example is the United Kingdom. In the UK, it is not every visas, but certain types like work visas will let you apply for the permanent residency after about 5 years of residency. United States, the immigration system does not work that way at all. Instead, there are several green card categories, and you have to simply pick and choose which one you're gonna apply based on your eligibilities. So, for example, even if you live in the United States for 10 years and with your TN visa or E2 visa, it does not automatically lead to a green card. So that's the system we are looking at. The US green card system is primarily broken into two ways. One is the family based and the other one is employment based. Under the family based, the immediate relatives category is for the US citizen spouse, unmarried children under the age of 20, and parents if sponsoring citizen is over 21. And preference categories have multiple subcategories. For more detailed information, you may look at the Department of State's visa bulletin. But a couple of good examples for these subcategories are spouse of U.S. permanent resident and brothers and sisters of U.S. citizens. Employment-based categories are broken into a total of 5 big categories from EB1 to EB5. EB1 is generally known as extraordinary ability case. EB2 is for national interest waiver, and PUM case. PUM case is basically where the application process go through the Department of Labor first before you submit the application to USCIS. EB3 is also going through the PUM processing based on the company's sponsorship. EB4 is religion-based, and finally EB5 is the investment-based. For these employment-based categories, Ian will address more detailed information later on about our presentation today. So, what is the family-based green card? The immediate relatives are the most popular way to process your foreign national spouse's green card case. The preference-based categories have a total of 5 different categories from F1 category to F4, but the well-known examples are the ones I mentioned before: the spouse of U.S. permanent resident and brothers and sisters of U.S. citizens. But a big issue of these preference-based categories under the family immigration is that these cases processing governed by the visa bulletin, which causes backlogs a lot of times. This means that while green cards for the immediate relatives are always available, the green cards for the preference-based categories may not. Depending on which countries you are from and or which category you are applying for, there may be some significant delays before the green card is finally approved. For example, F4 category, which is for the brothers and sisters of U.S. citizens. This category needs to wait almost 17 years nowadays. Okay, so these limited numbers of green card, rules made by the visa bulletin applies to employment-based green card categories as well. Each employment-based green card category has an annual cap of how many green cards can be issued. So once a particular category reaches the annual cap, then the application may experience some delays, and that's why it is important to check the monthly visa bulletin announced by the Department of State when you are preparing for your green card application. So next, let's talk about the process for the family green card case. The review process is basically 2 parts. One part is whether petitioner, and then beneficiary really has bona fide relationships in marriage or parents or child or sibling relationships. That the whole point of I-130 petition, and then the second part would be the deciding whether it is going to be consular processing or adjustment status inside the United States. So you have options, which part of the processing you are going to apply, taking routes. If a beneficiary is outside of the United States, then approved I-130 case by USCIS will be transferred to a place called National Visa Center, where the beneficiary will need to submit the required civil documentation. And then the case will be finally transferred to the U.S. Embassy in the country where the beneficiary is currently residing for the immigrant visa interview. But if beneficiary is already inside the United States, then the beneficiary may apply for the adjustment status by filing a Form I-485 with the USCIS. It's not required. The beneficiary who is already in the United States may decide to file I-130 only and then go back to his or her home countries for the immigrant visa interview. That's fine. But we are talking about alternative options for those people who are already inside the United States, and maybe a lot faster. That's why many people prefer this way. But filing Form I-485 with the USCIS for the adjustment status will be another option. Some situation requires additional processing. For example, when marriage-based green card case is filed, USCIS will impose a condition on the green card if the marriage has not been more than 2 years. So the beneficiary will need to go through the conditional removal processing after 2 years of the conditional green card. So that's pretty much all the family-based categories processing. And with that in mind, let me turn it over to Ian, who will guide you through the next part of our presentation. He will cover more details of employment-based green card case, particularly EB1A extraordinary ability and EB2 national interest waiver. So please stay tuned.
Great. Thank you very much, Yonki. And as Yonki had mentioned with the family-based cases, there is typically a 2 or 3 step process. The first step in the process is more of an objective process, part of the process where they're looking at do you meet the immigration requirement? And then the second part is whether or not you are applying for the adjustment of status or applying for consular processing. And then sometimes there's a third part where you have to remove the conditions. And those are limited set of petitions where they give you the green card for a couple of years, and then they say that you have to file something to remove the conditions. Now, the employment-based are exactly the same. They work in the same way in the sense that they're either a 2 or 3 step process, and there's an objective part of the process, objective in the sense that you're objectively trying to meet the whatever the requirements are. So on the family-based side, if you're marrying a U.S. citizen, you're showing that it's a bona fide marriage. But when you're looking at the employment-based categories, the law sets out what those objective requirements are to meet the first part of the process. So the first visa that we're going to talk about is extraordinary ability, EB1A. And for this one, what the government does to meet the first part of that process, or what the government requires that you do, is that they list a number of requirements, and there are 8 that are listed here, and they say that you have to meet at least 3 of them. So what this category is trying to do, it's saying we'll give you a green card if you have risen to the top of your field with respect to your profession or your field. So let's say that your field is in cyber analysis or cyber crimes, and you have written papers on that, and the government is seeking your advice with respect to how to limit people's ability to hack systems. And let's say people are asking you to present. And let's say that there are organizations that are asking you to maybe come and judge other people. Let's say there's some type of competition of who's written their best paper or who has come up with the most novel idea, or if you're making a high salary. All of these criteria, they're looking at whether or not someone has risen to the top of their profession. So, for example, if they're making a really high salary, then one might think that they are making that really high salary because they have actually risen to the top. If they're judging the work of others, when you think of American Idol and you say, who are the judges? They're all people who are already famous and who have risen to the top of their profession. So all of the criteria are really they're all there to ascertain whether or not the person has risen to the top of their profession. And as I said, you have to meet at least 3 of them, but it's ideal if you can meet even more, because even if you've met 3, there's another analysis that they do where they look at whether or not just really and holistically, whether or not you have risen to the top of your field. And that can be a fairly subjective analysis. So the more of the criteria that you have actually met, let's say you've met 4 or 5 or even 6 of them, or in some cases, people may even meet all 8 of them, that's going to be useful for you. So the next one that we're going to talk about is EB2, National Interest Waiver. So EB2 is broken up into 2 different categories. It's broken up into a company sponsoring you for a green card, that's a perm process, and then the other is National Interest Waiver. Now, what National Interest Waiver is saying is they're saying that you have whatever you're coming to the United States to do, that it is of national importance and the government feels that it's of national importance. So the very first thing that you would do with a national interest waiver petition is define what your endeavor is. So your endeavor is the reason that you are coming to the United States. And this can be something that does take quite a bit of time and effort to define because it should be specific and it should be crafted in a manner that gets you the check mark in the first box, and that is that your endeavor has is of national importance and substantial merit. It could be that you are creating jobs in the US, but it would have to be a significant number of jobs, in particular if the people that you'd be creating the jobs for are located in economically depressed areas. It could be the example that I used before, a cybersecurity expert that is coming to the United States to roll out innovative technology or new ideas that would advance the field. It could be we did a national interest waiver on someone who was assisting the U.S. government with counterterrorism methodologies. So, really the endeavor can be any endeavor, and then the assessment is whether or not it rises to the level of being nationally important. So it definitely is a very high bar. The second requirement is that the person is well positioned to advance the endeavor. So we're going to look there at their education, their work experience, but I think more important is really what is their track record? Have they done it before? And how much have they advanced the proposed endeavor? So if you're saying that you're going to structure the endeavor based on saying that you're going to create a number of U.S. jobs, then you would have to show probably that you already have an entity in place and that you already have created a large number of jobs, and then draft a business plan to show how you plan to create more, and then maybe even get an economist report to show exactly how those jobs could how those jobs are going to be created to be able to show that it's going to rise to the level of national importance. And then the final thing is that the government has already recognized that they say that protecting U.S. jobs is of national importance, and so they want you to kind of do an analysis to say, well, okay, we've already recognized that the saving U.S. jobs is important, and that most people have to go through this labor certification process, the EB-2 process, which you have to prove that you can't find a qualified U.S. worker. And so you have to provide evidence to show why is it that even though we've already said that the government has already said that this is of national importance, that they should still get the green card. So that's the analysis for NIW. And just to keep in mind for a national interest waiver, you do have to, there are threshold considerations. So before you even look at the harder part, which is proving the three prongs of Danisar, Danisar is the case that you use to that sets the requirements for national interest waiver. But before you even get to that, you have to meet the threshold requirements, and that is that the person has to have an advanced degree. So that's going to be a master's degree or higher, or a bachelor's degree plus 5 years of progressive experience. Or if the person doesn't meet that, then there are a list of criteria under exceptional ability, and this is not to be confused with extraordinary ability, which is a completely different standard, which is what I talked about in EB1A. But there are another set of criteria which relate to exceptional ability that some of them are quite similar to extraordinary ability, but it definitely is a lesser bar. But someone who had a high school degree, for example, might still be able to qualify under this category if they have met three of the seven criteria that are listed in the exceptional ability category. So. The next thing that we're going to talk about is really just how we apply for both of these, the EB1A and the National Interest Waiver. And both of these are a two-step process. And the first part of the process is filing an I-140 petition. So that's going to show that either if you're doing EB1A, that you've met three of the 8 criteria or more, and if you're doing national interest waiver, that your proposed endeavor is of national importance and has substantial merit, and that you've met the other 2 criteria as well. And then if the category is current, and surprisingly enough, the category is current for both of these categories for many countries, most countries. So, and this is unusual because under EB2, it was not current for some time, but it is current now. So you are able to file an I-485 petition, and if not, then when you have an approved petition, you can do consular processing. And the analysis is going to be the same as what Yonki described. If you're in the United States, you can file an I-485 if the category is current, and if not, then you're going to be doing consular processing. And if you do file an I-485, you're going to be filing. You can file a work authorization form and a travel authorization form. So those are two things to keep in mind. And then the one good thing about this, both of these areas as well, is that you are actually able to self-petition. So you don't need an employer for either of these two areas. So that is something to keep in mind. Perfect. So the next category for moving from a visa to a green card, and just to, these when we're moving from these categories, we there are lots of different visa types that people move from. But one thing that I didn't mention is for the EB1A, often we see people moving from an O1, so they have an O1 and they move to EB1A. Because the O1 criteria are very similar. It's a very similar process, except it's a non-immigrant visa. For these other categories like national interest waiver and EB2 perm and EB3, it can be any visa type. It can be someone's on a TN, it could be someone's on an H-1B visa, really any visa type, because EB2 perm and EB3 perm, they're really just the description of where a company is sponsoring you for a green card. So it is a way that many, many people get green cards in the United States, but usually those people are already working for the company. It's not required that they're working for the company already, but usually that's the case. So they could be on a TN visa, an H-1B visa, et cetera. So that they could have work authorization. You could be here on an E2 spousal visa and have work authorization because usually, because of all of the steps that the company has to go through, they normally do want to have some familiarity with the person before they're going to go through the time and expense associated with sponsorship. And the time and expense is related to the process, which is a process where a three-step process where first you have to do something with the Department of Labor where you have to prove that you cannot find a qualified U.S. worker, and that's the perm process. And once that's done, you can file the I-140, and depending on whether the category is current, the I-485. So the perm process is, as I said, it's really showing that you can't find a qualified U.S. worker, but that is quite an extensive process where you actually have to do a job posting for a job that really doesn't exist and come up with a job description, come up with a particular wage, and then interview people. And if you find a qualified U.S. worker, you have to stop the process. But if not, you can move ahead. And we have already talked about the I-140 and the I-485. So the next category that we see people moving to a green card is EB5. So EB5 is a really popular category for people on E2 visas, but we also have people on lots of other different visa types, both under the Regional Center and Direct Investment Program. So the Regional Center program is a more passive investment where the individual is, sees let's say there's a Hilton hotel chain in there expanding and they want to raise capital through the EB5 program, then they're going to attract investors to do that and they can participate in the EB5 program to get the green card. Or direct investment could be somebody that just wants to get a green card through opening a business or investing in a business. So it could be somebody like opening a gym or something like that and doing that. So the EB5 requirements in a nutshell are, twofold, really investment and job creation. So the first is you have to invest either 800,000 or 1,050,000 in a new commercial enterprise. The new commercial enterprise is not brand new. It can be an entity that has formed after 1990. And the difference between the two amounts, the 800,000 and the 1,050,000, is whether or not the business is in what's called a targeted employment area. And if it is in a targeted employment area, then it is going to be the lower amount, and if not, it's going to be the higher amount. And it does have to be investment that is investment that is new investment that is put into the business entity, rather than, let's say, someone that's on an E2 and they're accumulating revenue over time in retained earnings and then spending it. That's not going to be sufficient. The second part of the requirement is job creation. You are required to create 10 full-time jobs, direct jobs for direct investment. So those are going to have to be W-2 employees. And it is full-time jobs, not part-time jobs. And for indirect jobs, that can be, if it's a regional center, you can count indirect jobs. And what that is an economist basically saying that because this project is here, so because, for example, like the Hilton hotel chain is here, because as a result of that, there are going to be other things that have been set up, like maybe a dry cleaner, a restaurant, or other things like that, where the people don't directly work for the enterprise, but those are going to be counted towards. And those usually constitute a very large percentage of the jobs related to regional center. Both need a business plan, and the investment does have to actually be linked to job creation. So that's an important thing. In particular, when you're looking at a lot of E2 clients, they have purchased a business and given the money to the seller, and does not work for EB5 because the money actually does have to be invested in the business. And once it's invested in the business, then it is used to create those jobs. So the timing of the investment does really matter. And you do want to make sure that you are looking at the people that you're hiring and making sure that they actually have green cards or are U.S. citizens, because that is a requirement that the workers have to either have green cards or be U.S. citizens. The filing, oh, sorry, wait, before the filing, source of funds is very, very detailed for EB5. You have to prove that the money came from a legitimate or lawful source, and that is an extremely time-consuming exercise. And for EB5, the filing is the I-526 petition or I-526E if it's a regional center. And then depending on whether the category is current, you're going to be filing an I-485 or consular processing. And this is a three-step process where you do have to remove the conditions at the end. So you get the green card for 2 years. And then after that, you file to have the conditions removed. There are some other green card options that are available. Diversity lottery is a one where they pick 50,000 or so people every year. There's a process that should be starting. I think that it was delayed last year and they revamped it somewhat, but it's going to be a process that's going to start up again. So that is a way that people often get green cards. We usually have at least one client a year that has obtained the green card through the diversity lottery. There are some humanitarian-based green card options. So if you're a victim of domestic violence or you help the police solve a crime, those are all both humanitarian. It's asylum. Those are all options for green cards. And then, of course, we do hope for immigration reform one day. So the other kind of thing to keep in mind is timing. So especially with some green card options that might take a long time. So EB5, for example, could take 4 to 5 years for a petition to be approved. And if something's going to take that long, then you do have to make sure that you have you're maintaining underlying status. And if you have a particular visa and you're maintaining underlying status, depending on which visa it is, it might impact your ability to travel. Because if you're filing an I-485, for example, you're going to be filing for travel and work authorization, but those take around 9 months to be approved. So planning is really key with respect to all of these different strategies. And when you're looking at the underlying, like if you file the I-485 or if you're waiting to file it, you do have to look at your underlying visa, because if you're of a TN and then during the green card process you had to renew the TN, you may run into difficulties depending on what's being filed, because that's a single intent visa. Whereas if you have an H-1B, it may not be a problem. And we often do have people who do parallel strategies. We have people that file like maybe an NIW petition and an EB5 petition because maybe the NIW isn't as strong. Or we have people that file the EB5 petitions and then they marry a US citizen and get the green card a different way. So definitely parallel green card strategies are fine. And really the key takeaway with planning is with considerations is planning. Planning is really key to everything, because you do have to most of these are longer term. Even the family-based petition marrying to a U.S. citizen, there's a process at the beginning, but then even when you get the green card, once you've had the green card for 2 years, you have to file something else to remove the conditions. And that removal of condition form takes a long time. So people are in the process or in the system for years for many of these visa types. Oh, I think you're on mute. I think you're on mute, Yonki.
Okay, thank you, Ian. That was
No
a very
problem.
informative and great presentation. With that, let's go ahead and take a look at some questions. We do not have any questions today. Okay, great. In that case, thank you all for joining us today. We hope this webinar has been very helpful for your journey to the United States green card and permanent residency. If you have any additional questions, please feel free to visit our website and schedule a consultation with our team. We look forward to seeing you at our next webinar. Thank you.
Perfect. Thank you very much. Okay. Bye-bye.